Well, we're shifting gears a little bit in the course for the rest of the semester now as we begin to look at social institutions in regards to diversity. And since this week, the social institutions we're looking at involve the institution of education as well as the work world, this seems to be a very appropriate time to talk a little bit about affirmative action. The debate about affirmative action is very active in popular modern discourse and almost always focuses on the use of quotas. In fact, quotas in hiring or admissions were declared unconstitutional in 1978 in the case of the Regents of the University of California versus Bakke. This was a landmark decision of the United States Supreme Court. Bakke was an engineer and a former Marine officer who was seeking admission to the University of California, Davis Medical School, but was rejected for admission by that school and other institutions due in part to his age. He was in his early 30s while applying, and a lot of the schools determined that he was really too old to begin a study of medicine. After twice being rejected by UC Davis, he brought suit in the California Supreme Court, challenging the constitutionality of the school's affirmative action program. That court struck down the program as violating the rights of white applicants and ordered that Bakke be admitted. The United States Supreme Court accepted the case amid wide public attention at the time. Eventually, the Supreme Court upheld affirmative action, allowing race to be one of several factors in college admission policy. Note, one of several factors. But the Supreme Court ruled that specific racial quotas, as UC Davis had in place, where 16 out of 100 seats were set aside for minority students in the medical program, that such specific quotas based on race were impermissible, although in general, affirmative action continued to be acceptable. But many people complain about the use of quotas in educational admissions and also in hiring practices, believing incorrectly that quotas continue to be used in such decisions. Because of that, they declare an opposition to the concept of affirmative action without really understanding what it entails these days. There's an article written by David Benjamin Oppenheimer distinguishing 5 models of affirmative action, which describes different models for this program, which is very useful for us to understand when we get engaged in discussions about this. He argues that the differences in the models that he describes in his article and confusion over the meaning of affirmative action conflates the disagreement over the legitimacy of such an approach. So we're going to take a look at these 5 models. First, Model 1 is the Quota Model, and this is what most people view as the typical model of affirmative action. This would hold that a certain number of jobs or promotions, classroom seats, admission slots, and so on are set aside only for minorities or only for women. This was the plan that UC Davis used in the Bakke case, and according to the court's 1978 decision in that case, this is an impermissible racial discrimination. Plans linked to evidence of prior discrimination, though, and that are limited in scope to remedying the past discrimination can still be permitted, however. There was a case mentioned in Oppenheimer's article about United Steelworkers versus Weber, where a training program was created to train existing employees in skilled crafts, and half of the training slots were reserved for black employees, reflecting an attempt to correct prior discrimination in those training programs. Model 1 plans can also be imposed by the courts to remedy past discrimination and may also be created by specific acts of Congress. But in general, this is what most people think affirmative action is all about, and in most cases, with the exception of these very limited situations noted here, a quota model for admissions or for hiring based on race alone is unconstitutional. Model 2 is known as the preference model, and this is race-conscious or gender-conscious, but more flexible than the Model 1 plans. The race-conscious notion is going to come up in a later slide here, so just keep this in mind. We're talking about a Model 2 preference model here. The minority preference is established, but quotas are not established. An example cited by Justice Powell in his dissent on the Bakke decision was Harvard's use of questions at that time in 1978 that might favor minority applicants, such as whether an applicant has had to overcome barriers to success, whether the school's need for diversity in order to offer the richest education would be promoted by the applicant's admission. While favoring minority applicants, such considerations would also favor any unusual or atypical white applicants or atypical or unusual male applicants for a slot, whether you're hiring or admitting someone to school. So it doesn't exclude white applicants or male applicants. It just points towards those who have more difficulty, which is oftentimes the minority applicant. Preference for hiring veterans, by the way, is another example of the preference model, but this really doesn't come into affirmative action itself. Model 3 is the self-examination model, which is, again, legal and utilizes goals and timetables for the inclusion of women and minorities in certain job categories. Government and large private industry entities often use this in hiring. When we hired for positions in the Division of Family and Youth Services or the Office of Children's Services some years ago, we would get reports about what were known as underutilized populations. And although we were not required to interview underutilized applicants who were eligible for the job, we were required to give those applications consideration for scheduling interviews. If in comparison to the community at large, a certain population is underrepresented or underutilized in a particular job category, that population might be targeted for inclusion in one way or another. The assumption is that in the absence of discrimination, the percentage of qualified women and minorities in the job market should be reflected in the employment statistics of the employer. So if there are 15% Alaska Native individuals in the community, then it would be expected that the employer would have 15% of its employees from that same population. If there is no non-discriminatory reason for such disparities, then the employer adopts a goal of mirroring the job market, establishes dates by which to accomplish such a goal, and then assesses whether the goal is met. So continuing to monitor hiring practices and whether the underutilized populations are being included in hiring and in admission. Most federal employers must use such a model, and selection devices that might discriminate against a minority group, such as some standardized tests or some physical requirements, can only be used if they have a clear connection to job duties and to job requirements. Model 4 is the outreach model, and this is based on the assumption that a workforce or school enrollment that contains few women or few minorities is the result of insufficient knowledge of the opening or insufficient communication. So more vigorous recruitment efforts are made to engage minority populations in applications. Such practices as hiring by word of mouth, through nepotism, by selection from specific schools or specific neighborhoods, from promoting from within at times when there's already an imbalance in terms of majority and minority employees. All of these kinds of practices are really opposed to the outreach model, and it is the kind of thing the outreach model tries to overcome. The outreach model also opposes favoring the children of alumni or prominent community figures as well. So this assumes that gender and race discrimination that has created social barriers make it harder for women or minorities to qualify for jobs traditionally held by white males, such as management positions, for instance. And so this includes offering support programs or special promotional classes to enable such persons to encourage their application. Another example might be that job postings might be placed in community centers that are frequented by a high percentage of minority individuals, for instance. The fifth and final model of affirmative action that Oppenheimer describes as the non-discrimination model, and it actually has two aspects, active and passive non-discrimination. The decision is made to not discriminate, to act to avoid it, and to prevent employees from discriminating, and also to abandon practices which may have a discriminating effect. For instance, training employees, part of that training might be for teaching hiring individuals how we have a tendency to hire people who are similar to us or to connect with people who have similar interests to us, and how that limits the pool of individuals that are hired when those individuals are different, as minorities often are. Passive non-discrimination involves resolutions as the result of legal judgments or settlements of discrimination claims, perhaps hiring or admitting a person who claims to have been excluded due to discrimination. Those are the 5 models, and you can see that with the exception of the quota model, there are 4 other models of affirmative action that are legal and legitimate and can be utilized to balance the employment market and balance college admissions and admissions to other institutions of higher education that might remedy some of the issues regarding discrimination in our history. Now we'll take a look at a few decisions that have been made by the courts over the years that have helped to shape affirmative action practices today. Of course, I already mentioned UC Davis versus Bakke in 1978. The Gruder versus Bollinger case in 2003 was a landmark case of the Supreme Court concerning affirmative action in student admissions. In this case, it was the University of Michigan Law School that was sued by a prospective student because she alleged that she had been denied admission because the school gave certain minority groups a significantly greater chance of admission. In this particular case, University of Michigan Law School admitted that its admission process favored certain minority groups, but argued that there was a compelling state interest to ensure that there was a critical mass of students from minority groups. The court held that a student admissions process that favors underrepresented minority groups, again, there's that underutilized or underrepresented term, so that such an admissions process did not violate the 14th Amendment's Equal Protection Clause so long as it takes into account other factors evaluated on an individual basis for each and every applicant. This decision largely upheld the court's decision in Bakke, which allowed race to be a consideration in admissions policies, but held that racial quotas were unconstitutional. So Bakke didn't say that race couldn't be considered, but it did state that it couldn't be the only consideration in admissions. In another case in 2003, Gratz versus Bollinger, a separate case decided on the same day as Gruder, the court struck down a points-based admission system that awarded an automatic bonus to the admission scores of minority applicants. And so you see the rulings here are refining more and more and more how race can come into play in decisions regarding admissions and hiring. Another rather famous case came about in 2012 when the United States Supreme Court heard arguments for Fisher versus the University of Texas. Abigail Fisher was a white student who was challenging the University of Texas' consideration of race in its undergraduate admissions process. Fisher was denied admission to UT Austin in the fall of 2008 and argued that the UT's use of race in admissions decisions violated her right to equal protection under the 14th Amendment. It's just a little bit of history in this. The University of Texas had ceased a race-conscious admission process in the 1990s after a circuit court decision on such matters. And in response, the Texas legislature adopted the top 10% law in which seniors in the top 10% of their high school class were guaranteed admission to any Texas state university. The objective of this law primarily was to draw the best students from each Texas school, including schools from predominantly Black or Hispanic areas, in order to achieve higher levels of diversity on its campuses. But following the Supreme Court's upholding a race-conscious admissions program at the University of Michigan in Gruder versus Bollinger that we talked about just a few moments ago, the University of Texas then reinstated a consideration of race in admissions decisions for those who did not fall into the top 10% law. So the top 10% still had automatic admission from all those schools around the state, but that after that, a race-conscious decision could be made, weighing race as one of several factors in admission decisions. Fisher, as it turns out, was in the top 12% of her graduating class and so didn't get automatically admitted and did not get admitted on the strengths of other consideration for the remaining seats in that freshman class. So in 2013, the Supreme Court ruled by a rather decisive vote to vacate the Texas Circuit Court's opinion upholding the university's initial decision not to admit Fisher and remanded the case back to the Fifth Circuit for review under the strict scrutiny standard. Now, this is Fisher 1. This is the first ruling by the Supreme Court regarding Abigail Fisher. Strict scrutiny, you have to get into constitutional law and all of this to understand this, but basically, strict scrutiny is a very high standard that the courts must use, and rulings using strict scrutiny can only be overcome, as I understand it, with some very narrow reasons involving compelling interests and things such as that. That's for legal scholars to understand, but just understand it's a high scrutiny. So it sent the case back to the Fifth Circuit and federal courts for review under the strict scrutiny standard. So the Fifth Circuit heard oral arguments in November 2013 and then ruled in favor of the University of Texas by a vote of 2-1 in July of 2014 and later declined to rehear the case. So Fisher petitioned to have the United States Supreme Court review the case again, and that request was granted in June of 2015. The case was argued later in the year, and the Supreme Court ruled in June of 2016 by a vote of 4-3, much more narrow than the first ruling. This is Fisher 2 now, The court ruled to affirm the circuit court's opinion, thus upheld the University of Texas race-conscious admission process for those students not automatically admitted under the top 10% law. What explains the difference, I don't know. In the course of those 2-3 years in between the first and second ruling, I don't know that there was a big turnover in terms of the bench. I mean, who was on the bench? But clearly the court had decided in the end, after it had been reviewed under a higher judicial standard, that the UT's race-conscious admissions process was constitutional, and so Fisher lost her case in the end. I might mention here, before I go into the last case, that a question that comes up from time to time in Alaska involves when tribes hire individuals for their positions, and you'll see in the job application, for instance, that there is a native preference for hiring, which seems to work against the notion that you can't single out a race for hiring. But just to point out that the Civil Rights Act of 1964, which banned all discrimination in hiring by businesses involved in interstate commerce, exempted tribal employers from that ruling. So a Native American can potentially sue a white employer for race discrimination, but as the law stands, a white person couldn't sue a tribe or tribal employer for that same discrimination. So it is legal for tribes to hire with a native preference. There are good reasons for that really supports the whole notion of affirmative action, the reason for affirmative action. But just to clarify a point that might come up when you think about this. So finally, you may have heard about the case involving Harvard again. This is a new case that was brought about in, I think, 2018 first. Again, I refer you back to Model 1's use of racial quotas or gender quotas, and the distinction with Model 2's use of race-conscious decisions. And in this particular case, it's going to come down to race consciousness again. In this particular case, Asian American students sued Harvard and argued that Harvard should utilize race-blind admissions. Their suit pointed to recruitment numbers and a Harvard program that sends recruitment letters out to high school students based on standardized test scores. So according to school policy, they look at the PSAT scores, and Asian American males living in rural states need to score a 1370 on the PSAT to get a letter, but white males in rural states only need a 1310. The attorney for the plaintiff said clearly that's race discrimination. The Harvard Dean of Admissions pushed back and said that the college uses this tactic to attract people in rural areas who historically may not have considered the school, and those standards are not used once students enter the applicant pool. So they're soliciting applications from individuals that they believe maybe wouldn't generally be considering application to the school, but once the application is made, those factors are no longer considered. This is actually an outreach, maybe not so much based on race as it is based upon economics, social class, perhaps. This is still in process, and so you're going to hear more about this. But in October 2019, a federal judge ruled that Harvard College's race-conscious admissions process does not intentionally discriminate against Asian American applicants. She conceded, though, that so long as race-conscious admissions policy exists, they will always penalize to some extent the groups that are not being advantaged by the process, though she said such a penalty is justified by an interest in diversity. And this is one of the points that universities are making about using race as a factor in admission, one factor of many, one that does not exclude admissions by whites for the same seats, saying that the educational experience, the growth experience for students is enhanced by increasing diversity on campus. It's a complex area, but it's a very interesting area, I think, and you'd be wise to be well-versed in this and to understand the distinction in the 5 different models, because you're going to run into a lot of conversations about affirmative action and why we shouldn't have affirmative action, and really most of the people that are arguing that don't really understand what it means these days. I hope this is of some use to you. I think this is good information, and let me know if any questions come up.